Welcome to the Pacific Research Institute's Next Round podcast. I'm Rowena Itchon, Senior Vice President, and with me is Tim Anaya, Senior Director of Communications. So I think everyone's really going to like our guest this week, Steve Smith, PRI Senior Fellow at our Center for Urban Renewal. Steve was a former police officer, also a former professor of criminal justice. And we're going to talk about what everybody's thinking about these days, rising crime. So Tim, you're in Sacramento. What's the latest on this Sacramento shooter?
Well, it seems to be coming out in drips and drabs, but the latest information that we had as of today, we're taping this on Monday, the 18th, is that 3 of the victims allegedly had an association with gangs. And they were involved in some sort of altercation with the alleged shooters that preceded the shooting. I think we speculate. A lot of people speculated about what caused this to begin. But there was a court filing from prosecutors here in Sacramento that laid out that 3 of the victims allegedly had gang affiliation. It kind of takes the discussion to the next level. What are we doing about gang crime in Sacramento and around the state? It's one thing, all the focus on guns and illegal weapons and all of that. But, here you have a massive gang incident now, literally steps away from the state capitol. So what are policymakers going to do? What are local and state policymakers going to do about this really epic gang crime that occurred literally right here, in the center of power in our state?
Yeah, Tim, all across California, we've seen, as everyone knows, an increase in crime, especially violent crime in our major cities. Oakland and Stockton are now up there with Detroit and Baltimore among the most violent cities in America. And even here in Santa Monica, this tourist hotspot, I have a lot of good memories of as a youth hanging out in Santa Monica. It's now considered one of the most violent places in the country. And I think an interesting thing is I think hopefully, citizens are waking up here in LA, in heavily Democrat LA. Karen Bass is now running neck and neck with businessman developer Rick Caruso. That's stunning.
Well, I think it will be interesting to see in that race. The recall of George Gascon is going to be front and center in the general election. Rick Caruso is an active supporter of the recall and a donor. We don't know where Karen Bass stands. All our friends on Twitter will correct me if I'm wrong, but what is she going to do as far as the recall? I would bet she on the natural might be something she would oppose. But if you're kind of sidling up to George Gascon, who the latest polling shows, I believe, is down to a 29% approval rating in LA. Boy, that's not an albatross you want to wear around your neck. Standing with him, could mean that you own all the problems that LA is facing on crime and other issues.
Yeah, and the latest on that, I read the other day, is they've collected more than 200,000 signatures. They need 566,000 to get on the November ballot. And they're hoping that this time, this is a second go around on the recall, that this time the recall can get on the ballot. But we're excited that later this year, Steve's going to be looking at the laws that have passed in recent years and their effect on public safety. No one has done a serious study on the cause and effect of so many of California's laws that we're looking forward to having this published, and I think it'll get a lot of great play.
Well, and you see there's a narrative of, people that promoted these laws. There's immediate pushback. They'll cite data that they'll say, there's no cause between Prop 57, Prop 47, some of these other measures, and this increase in crime or the increase in retail theft. But our eyes work. We see it every day. And so, I'm kind of interested to see this really honest look at what has been the result of these measures on crime in California. There was a big hullabaloo that Steve actually just wrote about this on our Right by the Bay blog, where there has been a pushback in the Sacramento shooting that, were these individuals granted early release? And actually, the fact checkers came out and said that's false to say they were granted early release. Well, no, as Steve says, they weren't unlawfully released. They weren't released against policy, but certainly policy changes were made and state authorities were given increased authority to increase the good behavior credits so that they did get out of jail after, serving only a very modest amount of their sentence. And so that, I think, is the issue that we explore on this podcast, and that policymakers need to be looking at is this a good idea? Now we're seeing the real life human consequences of these policy changes, and these are the direct result of policy changes. Are we happy with this? Is this working as the law intended? And if reasonable people on both sides of the aisle see these issues and even say publicly, yes, we should look at those. We should tighten up these loopholes. These were unintended consequences. Why is there such pushback from outside groups? So I think it's all a very interesting discussion. And, we'll certainly do a deep dive into all of these issues on today's episode.
So thanks, everyone, for listening. And here's Steve Smith. Welcome back to Next Round, Steve.
Thanks for having me.
So, Steve, we're having you back to talk about the debate over public safety policy in California that's flared up in the aftermath of this tragic shooting on K Street in downtown Sacramento. So let's start our discussion with a broad view of the issue. In your view, how did public safety policy changes play a role in the tragedy that took the lives of so many people and it injured so many others?
Well, I think you have to go back almost 20 years, back to 2000 when Prop 36 was passed, mandating drug diversion and treatment for individuals arrested with personal use amounts of drugs, which included methamphetamine, crack, heroin, et cetera. And we talk about diversion, what we mean is diverting people out of the formal criminal justice system and putting them in court-ordered treatment programs. But what we found is that, without, a stick to go along with that carrot, that people were at best attending and not internalizing the treatment programs that they were mandated to. And eventually, Prop 36 just sort of fell apart. Both the judges and prosecutors recognized that people given Prop 36 diversion without the chance that they could be sent to jail if they don't participate meant that they just weren't going to do it at all. And what that meant is that drug-related crimes really never dropped. You've got three kinds of crime and violence associated with drugs. The most scary one is pharmacological violence, and that's the crimes that are committed while they're under the influence of drugs. And ask any domestic violence victim about that, and they'll tell you that in most cases, the people who abuse them are high on drugs and or alcohol. And then you've got the economically compulsive crimes, and those are the crimes that are committed in order to buy the drug. Just because you make a drug legal, or maybe not legal, but decriminalize it, doesn't mean that the price is going to drop, or the price is going to drop significantly enough to allow people to add that to the daily market basket of goods that they need to buy to live. Drugs are expensive. They've always been expensive, and people commit a lot of crimes in order to obtain those drugs. And then the last kind of violence and crime that goes along with drugs is systemic. And those are the crimes committed by drug distribution organizations, if you will, or gangs. They're fighting each other for territories. They're fighting each other over routes of delivery, and they're committing, terribly violent crimes in order to obtain, if they can, a monopoly on drug distribution in the area. So this idea that, drug decriminalization is going to reduce crime is really kind of a myth. And then jump ahead, almost 10 years to AB 109. Because of the Plata decision, California got in hot water with the federal court. Because of the high prison population figures, the courts required that California reduce its prison population. So AB 109 was the response to that. It did a couple things. It designated a huge body of the inmate population as what are known as triple nons. Triple nons are nonviolent, non-sexual, non-serious offenders. And the triple nons were given priority for early release. And we saw releases in the neighborhoods of 50 to 60,000 inmates almost immediately. But a triple non really isn't a triple non. Everybody in prison, for the most part, is there on a plea deal, right? Very few people go to trial. And what that means is their commitment offense is not always reflective of the facts of their case because it was pled down, meaning the charge was pled down to a lesser charge. And that could include going from a violent felony to a nonviolent felony. Hence, somebody who's a triple non might not actually be a triple non. Then jump ahead to 2014 and we have Prop 47. That allowed inmates with felony convictions, again, the result of plea bargains, pleas that they pled guilty to with their defense attorney standing next to them, it allowed them to be released because their felony convictions were no longer felonies under Prop 47. And again, this was regardless of their conduct inside the institution. The CDCR can be a little bit, I don't want to say lazy, but maybe it is lazy because investigating cases inside of criminal institutions or prisons are tricky things because of the no snitch culture. So the way CDCR often records antisocial behavior inside of the institution is just in floor logs, meaning they'll write down bad stuff the inmates did to warn oncoming shifts what's been going on, but that won't find its way into an inmate's jacket or record. So we don't really know what those Prop 47 release inmates were like when they were inside the institution, unless you start mining the data and literally walk the floors and the tiers inside the prisons and read the logs to see what they were really like. And then a few years later, we have Prop 57. And Prop 57 allowed CDCR to, again, release thousands of inmates based on a new good behavior formula. Whereas in the past, a violent criminal had to serve 85% of their sentence and a nonviolent 50% of their sentence. We now allow inmates who have violent convictions to be released as soon as 50% of their sentence is served. So what that means is we have thousands of inmates out on the streets now really continuing their criminal conduct. And I'm not saying all of them. A lot of the people who voted for these measures did so because they believed it would, help reduce California's inordinately high recidivism rate. Recidivism is the likelihood that somebody will return to prison who's already been to prison because they commit a new offense. In California, that was running around 80%, which is amongst the highest in the nation. So they wanted to reduce that number, but the treatment programs available in prison and the educational programs didn't always keep up with demand. And now we're seeing the results of that in a rapidly increasing homicide rate in California.
So it didn't take very long before thoughts and prayers over the victims and their families turned into partisan finger pointing. And one debate has been over whether what happened truly amounted to early release. We've seen newspaper editorial boards, so-called fact checkers, and, liberals in Sacramento claiming that what happened here was the normal course of good behavior credits and nothing could have been done to stop the release of those in question. Others argue that what happened is de facto early release. So what's your view? Who's right here?
Well, I guess the question is, was it a legal release or an illegal release? And under Prop 57 and the COVID rules as they were applied, particularly in 2020, I guess the Martin release was legal, but should it have happened? The answer is no. He was given a 10-year sentence for a particularly violent domestic violence incident, which by the way, is classified under Prop 57 as a nonviolent crime, and I don't know how they get away with that. So his 10-year sentence, which was imposed in 2018, was over by early this year. Now, he did have some 500 days of credit for the time he served prior to conviction in the county jail. So if you apply that to the new release standards, then it was legal for him to be released, but it wasn't smart for him to be released. And given the fact that he slipped right back into criminal conduct, tells me that he didn't program or participate in any meaningful rehabilitative opportunities while he was inside the institution. And that's not really surprising because the Prop 57 rules actually only require that you be willing to participate in a treatment program in order to get the 50% reduction, which is really pretty absurd. On top of that, in 2020, there were 3 tranches of prison releases. In April, 3,500 inmates were released if they had 60 days or less to serve in their sentence. In July, any inmate with 180 days or less was released. And anybody who had no rule violations between March and July of 2020 got an additional 12 weeks of credit. So, under the COVID rules, almost anybody who could officially, and put quotes around officially, stay out of trouble while they were inside the institution got an early out. On top of that, Smiley Martin's kind of unique because it's obvious he was in possession of a firearm. And under Prop 63, he was supposed to declare his firearms upon conviction and turn them in. Unfortunately, Prop 63 doesn't have any real teeth because not declaring your firearms is only a misdemeanor punishable by a $100 fine. And it seems to me if the governor and the state legislature was serious about getting guns away from dangerous individuals, they would put some teeth in the Prop 63 law.
So, Steve, there's been a big debate in the past decade or so over these controversial good time behavior credits. Look us through how the process works. Do inmates actually have to achieve some of the benchmarks, like receiving their GED, which is the equivalent of getting a high school diploma, to receive good time behavior credits? Or are they really just handed out for trying? And shouldn't inmates have to make some progress toward rehabilitating themselves before actually receiving what a reward for so-called good behavior?
Yeah, it's a little bit of both. Certainly, inmates who achieve benchmarks like getting a GED are given a reduced sentence. But like I said earlier, they get those credits if they're willing to program, but are on a waiting list to get in the program. So that's really not a benchmark at all. That just puts them on the list for early release because they were willing to, but we didn't have something available for them.
So California has some of the nation's strictest gun laws, yet the alleged assailants in this case were able to obtain illegal weapons used in the shooting. So this begs the question, are lawmakers and other advocates putting too much faith in tough gun laws as public safety policy? Or are there holes in the law exposed by this tragedy that should be tightened up? And what were your experiences on this as a former public safety officer? What really should we be doing going forward?
Well, again, I'm going to point us back to 47 and 57. When Prop 47 was passed, it actually reduced the theft of a firearm under $950 to a misdemeanor. Now, 2 years later, that was corrected, but that meant that anybody convicted of stealing a firearm for a 2-year period in California only faced a misdemeanor, because let's face it, most guns are worth less than $950 that are stolen. Further, Prop 57 reduces the consequences for someone convicted of using a firearm in a crime. Under Prop 57, you're eligible for parole even if you used a firearm alongside somebody who didn't. So I guess what I'm saying is they're all equal now. If you used a firearm, it's the same as if you didn't. If you have multiple victims, you are punished as if there was only one. If you had multiple counts, you're punished as if there's only one. If you participated in a gang, those enhancements can't be used against you. If you're a juvenile, Prop 57 originally meant that juveniles could still be charged as an adult. However, AB 1391 was passed a couple years later, and that prohibits juveniles being charged as an adult, even in violent crimes, even in homicide. What that's meant is we've created a class of young offenders who can commit crimes almost without consequence. And, people think that, keeping juveniles out of the criminal justice system or out of prison is a good thing. And yeah, that's a great thing to strive for. But what it's meant to criminal street gangs is that they now have an army of potential soldiers at their disposal who can't be held to legal consequences as if they were adults. So if you've got a carload of gangsters, who's going to own all the drugs in the car? Who's going to own the guns that are in the car? It's going to be the juvenile. And what that means is they can be exploited by criminal gangs. It actually makes them less safe than they were when they could be prosecuted as adults. What else can I say? Prop 63, like I just mentioned, requires probationers to declare their weapons, but it has no teeth. $100 fine. Probation is backlogged. They're understaffed. The Department of Justice only has 45 agents to enforce, gun laws in California. Well, there's over 30 million Californians. There are millions of guns in this state. And putting it on the shoulders of a few people at DOJ to maintain the databases isn't adequate.
So, Steve, an ongoing controversy over the past decade has been the backlog in entering individuals in the state's Armed Prohibited Persons database. And state auditor has issued several scathing audits of the Attorney General's office's efforts to close a backlog over the past decade. How does the system work? Where do things stand today in eliminating the backlog? And from your perspective, did a breakdown in this system play a role in the Sacramento tragedy?
Right. Well, once you have committed a violation of the law that would put you on the prohibited persons list, really what needs to happen is immediate action to take away your firearms. For example, if you are served with a protective order, most commonly in a domestic violence case, you need to be required at that moment to surrender your firearms, and law enforcement isn't doing that. Likewise, people convicted of dangerous crimes, are automatically placed on the prohibited persons database. However, immediate action isn't taken to go and get their firearm. It's a passive system that requires compliance on the part of the person convicted, which is crazy. They have a 10-day window to self-identify any weapons that they have that qualify and turn them in. But without anybody out there to actually go and get them, how often do you think that really happens? Not often. And, and it's not just the special agents at DOJ that are understaffed. It's law enforcement everywhere. San Francisco PD down 400 to 500 officers, and their recruiting efforts aren't even coming close to keeping pace with their retirement and resignations. And that's not uncommon around the state. So the governor and the legislature need to make a robust commitment to proactively going after the weapons that are held by these some 22,000 people on the prohibited persons database.
So Gavin Newsom has been pushing a proposal to curb the spread of so-called ghost guns by allowing people to file civil lawsuits against those who distribute illegal guns. So what exactly is the governor proposing? And do you think this would have any measurable impact in getting illegal guns off the street?
I hate to speak this way, but I think it's political silliness to put the burden on crime victims or ordinary citizens to find a lawyer and go and sue the manufacturer of the components of a Gascon. Sometimes those components are manufactured out of state, so a California court doesn't even have jurisdiction. There are so many legal complexities to filing civil cases, and to put that on the shoulders of ordinary citizens is really in effect doing nothing at all other than garnering some headlines.
So, Steve, another public safety policy debate that boiled up in the state capitol was over Prop 47 and its impact on retail theft across the state. So several measures authored by Democrats and Republicans alike have been defeated in the Assembly Public Safety Committee. What were some of these proposals, and would any, in your view, make a difference in reducing the rise in retail theft?
A misdemeanor course of criminal conduct cannot be combined together in order to create a felony, right? So if you have somebody who's going from store to store to store, stealing less than $950, there is no way to increase that crime to a felony, meaning these are just multiple misdemeanors stacked on each other. That could be easily corrected by the legislature, allowing the stacking of misdemeanors to get a dollar value that places them prosecutable for a felony. What are they doing actually? SB 915 is going to make it illegal to conduct gun sales on state property. The idea is that that'll drive the gun shows off fairgrounds property. But according to Boston University, California already has 107 gun laws on the books, making us the most regulated state in terms of gun ownership. What we don't have is effective enforcement and consequences.
So in the shadow of the shootings at the state capitol, Republicans and Democrats alike have begun outlining proposed reforms in the wake of the tragedy. What are some of the measures that they're proposing? And in your view, would they make any difference if they were enacted?
people who are thieves, do a cost benefit analysis, right? They balance the cost of getting caught against the benefit of stealing the property. Under Prop 47 and 57, clearly we have failed to provide an effective deterrent to keep people from committing repeat theft offenses. Now, some of the statistics are showing that reported thefts have decreased. And I actually don't believe those statistics. What I believe is that people have given up on reporting because they know out of experience that nothing will happen to the people who are arrested. Nothing will happen as a result of their taking time off from work, paying employees to attend court hearings. They've just given up because they're frustrated. So I think that the dollar value of thefts and the number of thefts has gone up, despite the fact that some of the statistics indicate they will go down. And for district attorneys like George Gascon and Chesa Bodine to say that they will prosecute misdemeanors for petty thefts is just a lie. Yes, they'll get a conviction and then they'll immediately put them on probation. They'll put them on a probation that doesn't have any teeth, right? They'll put them on probation that allows them to violate the terms of their probation over and over and over and not send them to jail as a result of those violations. We can't have a system that's guaranteeing 100% that people released from jail or prison aren't going to commit another crime. But what we have now is a trend of increasing property crime and violent crime in California. And it's clear, like the Sacramento shooting and the murder of Jacqueline Avant late in December of last year, were preventable. Smiley Martin and Ariel Maynor were out on Prop 57 early releases that were accelerated because of administrative decisions made by CDCR under the government code, yes, that were legal, but were very dangerous. And the deaths of the 6 people in Sacramento and the deaths of Jacqueline Avant are just a few examples of what I believe are many homicides. In fact, homicides increased by over 500 between 2019 and 2020. And we're still waiting on the 2021 statistics. Here we are, halfway through April, and we still don't have them published. And I think the reason why is the Attorney General doesn't want us to see how bad 2021 looked. Bottom line, I think Prop 57 was a Trojan horse. It's vague where it needed to be and detailed where it needed to be in order to convince voters into believing that it would make them safer. When in reality, inmates are not getting the real and meaningful rehabilitation they should be, and Californians are less safe because of it.
So, Steve, as we close, what is your view? What should be done? What should we should be focusing on to reduce likelihood of another mass shooting like what happened on K Street and in the future?
We can't control what we don't know about. The mystery criminal out there who is, because they're mentally ill, plotting some sort of shooting incident, is a difficult thing to get a handle on from a law enforcement perspective. But what we can control for are the people that we know are violent, the people who have records for the use of weapons and crimes that Prop 57 is allowing to be released earlier. Those people need to be held until they have truly programmed. Back in 2003, Governor Jerry Brown was making a pitch that we needed to get away from determinate sentencing, right? And go back to indeterminate. So determinate sentencing was a fixed term, right? You either got the midterm, the mitigator to the aggravated sentence, and you served 85% of that. Well, what he found as mayor of Oakland was that hardcore offenders were getting their midterm sentence, and rather than taking the 15% early out, serving the time straight to avoid a parole or probation tail, meaning nobody would check their whereabouts, nobody would conduct a search, and nobody would test them for drugs. He saw that as a failure of the institutions to mandate that inmates participate in rehabilitative programs. And his theory back in 2003, when he was testifying before the Hoover Commission, was that we needed to go back to indeterminate sentencing. The hypothetical 5 to 15 or 5 to 20, meaning you served, a minimum of 85% of your 5-year sentence. However, if you didn't participate in rehabilitative programs in a real and meaningful way, you would remain in prison until you did. Unfortunately, that ran into tight state budgets and the Plata decision, which meant we were required to reduce prison populations. Now, we can glean the nonviolent ones from the violent ones with a little bit of effort, but we need to really drill down on the 10% of people in California who are committing 90% of the crime.
Thanks so much, Steve.
You're welcome.
If you like this episode, please tell your friends and subscribe to PRI's podcast at iTunes, Google Play, Stitcher, TuneIn, iHeartRadio, and Spotify. And when you're on these platforms, don't forget to give us a big 5 stars. If you don't subscribe to any of these, you can still listen on PRI's YouTube page, youtube.com/Pacific Research 1. That's the number 1. Thanks for listening. I'm Rowena Itchon. Hope you'll come back again for next round with PRI.